who don't know, I'm the Emily Warren, and I'm the president for the board of our local Oregon chapter of the ACC. I'm just finishing up my first term, and I've got one more to go. We had about 120 people sign up for this event, which is a really incredible turnout. And so either people find this topic really interesting or everyone needs last minute ethics credits, but in any event, we're really happy to have everyone here. And it looks like we have a lot of current members signed up as well as a lot of non-members. So I wanted to take this chance to just invite non-members joining to feel free to reach out to Stephanie, our administrator, or to me with any questions or for more information about joining the ACC. We're always happy to have new members join. And I also wanted to make a quick plug for our annual meeting, which is on December 15th. It's sponsored by Ogletree Deacons. It will be an employment theme, and it takes place from 4 to 6. It's virtual, and it's going to include a chocolate tasting with Theo Chocolates, an artisanal chocolatier out of Seattle. But you need to register by 3 p.m. tomorrow to receive your tasting kit. It's open to Oregon ACC chapter members only. So if you have any questions about that, please also, again, reach out to Stephanie or me for more information. And with that, I would like to introduce our presenters today. We're very happy and privileged to have our longtime sponsor, Markowitz Herbold, to present today. We have with us Lauren Blaesing and Harry Wilson. So by way of background, Lauren is a shareholder at Markowitz. She represents business clients in complex disputes. She's litigated cases involving partnership and commercial lease disputes, non-compete and non-solicitation agreements, financial elder abuse, business torts, breach of contract, class action, and professional negligence claims. She's recognized as a rising star by Oregon super lawyers and was honored by the University of Oregon Law as an outstanding young alumnus in 2019. So welcome, Lauren. And we also have Harry Wilson with us, who's a shareholder at Markowitz and the chair of the firm's government practice. He has extensive experience in high-profile, complex litigation, including the management of multiple cases with more than 100 million at issue, defending high-stakes class actions, and representing some of the most prominent public officials in Oregon. He currently represents the Oregon Attorney General in her litigation against Purdue Pharma and the Sackler family. And he's been recognized by the Portland Business Journal as an under 40 honoree and made benchmark litigation's under 40 hot list in 2016. So welcome to both of you, and take it away.
You're on mute, Harry.
Yeah. Emily, thank you so much for that really kind introduction. And I am really honored to be here today in front of the Association of Corporate Counsel with you, Emily, with all of your members, with all of the guests here today, and with my colleagues, Carrie Trujillo and Lauren Blaesing. So our subject today is attorney-client privilege for corporate counsel. Attorney-client privilege is one of those extraordinarily broad, extraordinarily difficult, and extraordinarily complex legal topics where I constantly find myself calling up Lauren and saying, wait, is this privileged or is it not? Or my phone rings and it's Lauren asking me the same question, and we dive into the law to try to figure out the answer. Over the years that Lauren and I have worked together, we've had the opportunity to encounter some of the same problems over and over again, some of the same questions, some of the same difficult, tricky, and sticky situations. And we'd like to talk about a few of those today about attorney-client privilege. But I want to emphasize one thing as we get started here today, and that's that Lauren and I are trying to help provide an issue spotting overview of some of the really tricky and common situations we see with privilege, and with attorney work product, but by no means is this comprehensive. Privilege, work product, and the ethical implications of confidentiality and how you represent your organization, your corporation, are really important questions. And the issues that we address today, that Lauren and I talk about, are not the complete and definitive answer for any of these questions. So I urge you, if you are really facing a tricky and sticky situation, to go beyond just what Lauren and I say today, and to look into the law or to consult outside counsel. Lauren and I will also be happy to answer any questions. We'll try to get to some during the presentation today, but if you have questions afterwards, please feel free to email or call us, and we'll do our best to answer them. But for now, we want to give you an overview of some of the things that we're likely, that we've seen in our careers with respect to privilege and work product. So today we are going to cover privilege. We'll talk a little bit about how that privilege affects both current and former employees. Lauren is going to then cover work product and waiver and the differences between waiver for privilege and for work product. And then we'll dive into some questions and answers. Let's start at the top. What is attorney-client privilege? Attorney-client privilege is a confidential communication. It's a communication that is made between a lawyer and the lawyer's client, or agents of the lawyer and the lawyer's client, for the purpose of seeking, obtaining, or providing legal assistance. That's the high-level overview. A few things are really important to keep in mind with this big, broad definition. First of all, the communication has to be intended to be confidential. It is not an attorney-client privilege communication if your organization says to you, we would like your legal advice on this question, and we're then going to disclose it to the opposing party. So for example, if you are negotiating with another party a contract, and you provide legal advice to your procurement office that the contract should include a merger clause, and the procurement officer puts the merger clause into the contract with the intention of eventually sending that contract to the other party, that merger clause is not going to be privileged. That is intended to be public from the beginning. So it's not a confidential communication. The communication also must be for the purpose of seeking, obtaining, or providing legal advice. So business advice is not privileged. You in your role as a corporate counsel are asked by an officer of the corporation to provide your take on whether the corporation's stock or units are appropriately priced. And the question is purely one having to do with the cash flow of the business or some other financial consideration of the business. Your take on that is a business communication. It is not a legal communication, and it won't be privileged. The basic tenets of attorney-client privilege are the same across federal law, across most state laws, and throughout the United States. But there are a lot of small differences between jurisdictions. And so when you are considering whether a particular communication is attorney-client privilege, it matters what law applies. Federal law has an attorney-client privilege that is strictly a creature of common law. It is not statutory. In contrast, Oregon's attorney-client privilege is an evidentiary statute. It's not a rule. It's not a rule. It's actually codified in the Oregon statutes, and it is interpreted by Oregon courts according to the principles of statutory construction, not as a matter of common law. So while the federal attorney-client privilege common law rule and the Oregon statutory attorney-client privilege rules are very similar, they tend to be interpreted differently. To give you an example, when the Oregon courts are trying to figure out what attorney-client privilege means in Oregon, they start with the text of Oregon Evidence Code 503, and then they look at the text and context of OEC 503 to try to determine the meaning, looking at dictionary definitions, and then at the context of the words within the code. And if they can't determine what it means by looking at text and context, then they look at legislative history. And if legislative history doesn't help, then they look at the rules of statutory construction. What Oregon courts don't typically do in the first instance is look to federal law to determine what attorney-client privilege means. They might look backwards and say, well, federal law meant this, that, or something else at the time the statutory OEC 503 was passed or amended, and therefore the legislature took that into account, but they will not generally look to federal law in the first instance to interpret attorney-client privilege. So are there differences? Are there important differences between Oregon and federal attorney-client privilege? Well, there are differences. The rules are set out slightly differently, and the exceptions are slightly different. The rules of waiver are slightly different. And the nuances and intricacies of those differences are really long and complicated. So we'll leave that for the Q&A if you have any questions about any differences, or if you have a particular issue that comes up, please let us know. Why is the attorney-client privilege important at all? I want to back up for just a minute and talk about the ethical underpinnings of why we talk about privilege in the first place. Privilege is important because communication with your client is important. And communication with your client is one of the essential ethical obligations of any attorney. You can see that in the Oregon rules of professional conduct, especially, but not exclusively, in RPC 1.1, 1.4, and 1.6. So in 1.1, you as a lawyer have an ethical obligation to be thorough and prepared in your representation of your client. In 1.4, you have an ethical obligation to be reasonably informed about the status of the matters that you work on for your client, and you have an obligation to keep the client informed of what's happening with those matters. And in 1.6, you have an ethical obligation not to reveal the confidences of your client without your client's permission. The three rules that I just mentioned here are also, they're very consistent with what is some of the former ABA model rules before the ABA adopted the more recent model rules a few decades ago. But it was quite common at one time for courts and for the ABA to say that a lawyer had an obligation to be fully informed. And what that meant was the lawyer had to be thorough and prepared and to understand the matter that the lawyer was representing the client on. Well, the attorney-client privilege arose as a way to ensure that lawyers were able to have that kind of information and preparation and thoroughness from their client. The purpose of the privilege in both federal and Oregon law is to encourage full and frank communication between attorneys and their clients. The privilege serves in part to effectuate the ethical obligations that lawyers have to their clients. I want to give you just a quick caveat to that. That doesn't mean that the rules of professional conduct are applicable to construing the breadth of the privilege. So while the privilege arose in part because lawyers have an ethical obligation to their client, courts don't typically look to the extent of the rules of professional conduct to interpret the privilege. Okay, so who is the client? This all sounds very simple until you actually start looking at these tricky questions. Our friend here, the bear, and we'll have a lot of bears today as we move through this slideshow, is wondering, Can an entity be a client? Can OHSU be a client? Can a corporation be a client? Though this was decided in 1915 by the United States Supreme Court, an entity can be a client, and an entity itself cannot have a conversation with a lawyer, and therefore an entity like an organization can speak through certain individuals within the organization to a client, to a lawyer, and those communications can be privileged. And that was stated in Oregon in the OHSU v. Haas case from 1997. That United States Supreme Court case and the Oregon case also match up with Oregon's rules of professional conduct, which expressly state that a lawyer can be retained by an organization and that the organization acts through its authorized constituents. So you as in-house counsel for a corporation have to figure out who within that corporation speaks for the corporation. Who is your client? Let's take a look at the next slide and we'll see some formulations that courts have worked on to figure this out. Who is within the cone of privilege? So first of all, of course, you as lawyers, whether you be inside or outside counsel, and your agents, your paralegals, your assistants, your colleagues, all of you can be lawyers for the purpose of privilege. So who speaks on behalf of the client? Well, first of all, it's long-standing precedent in Oregon and in federal courts that the control group of an organization has authority to communicate in a privileged manner with counsel. And the control group typically means people like C-suite officers and directors, or the member managers of an LLC, or the directors or executive director of a not-for-profit organization, CFOs, other high-level finance officers, chief operating officers. All of those are what the courts would consider a control group. Until 1981, that was the only people who could speak on behalf of an organization. And courts frequently held that if in-house counsel or outside counsel spoke with individuals who are outside of the control group, then those communications were not privileged. But in 1981, the United States Supreme Court decided the case Upjohn versus United States. And in 1997, the Oregon Supreme Court decided OHSU v. Haas. And each of those cases held that any employee of a corporation or organization can, in certain circumstances, have privileged communication with in-house and outside counsel. Upjohn established a 5-part test that the communications involve information necessary to supply legal advice, that the information is not otherwise available from the control group, that the communications concern matters within the scope of employment, that the communications were for the purpose of supplying legal advice, and that the communications were confidential. And if those factors were met, and they're not exclusive, some can be more dispositive than others, it depends on the circumstances, but if at least some of those factors were met, then a lawyer's communication with a non-C-suite, non-director employee was subject to privilege. Oregon hasn't officially adopted all 5 of those rules as tests, but in most instances, I think it is likely that Oregon courts would apply the same kinds of tests to figure out whether a communication between a low-level employee and a lawyer were covered by privilege. This rule also applies to contractors, so it doesn't have to be an employee. An in-house or outside counsel can have a privileged conversation with the contractor of an organization if the contractor is operating as a functional equivalent of an employee. I think the functional equivalent language can be a little bit misleading. It's not necessary that the contractor work the same hours as an employee, have the same tasks as an employee. in order for the privilege to extend to a contractor. What the courts are actually looking for is to understand whether the contractor has information or is gathering information or is working on litigation in a manner that the company needs its counsel to have attorney-client privilege communications with that contractor, and that the contractor, as an agent of the company, as an agent of the organization, is the only individual that has access to that information. So that's a little confusing. Let's talk about what it actually means in terms of a case. Imagine that an organization is involved in litigation and hires a PR firm. Well, go back one more, Lauren, sorry. And it hires a public relations firm to help gather information that its lawyers might use in litigation and to handle the heavy press scrutiny that the organization is facing as a result of litigation. The lawyers for the corporation need to speak to the PR firm to learn information the PR firm is gathering to support the litigation, and they need to be able to speak to the PR firm in order to help translate documents and other things that are happening in the litigation, so that the PR firm can advise the corporation about what it all means for the press scrutiny. That is the kind of thing that can, in some instances, meet the functional equivalent test. And there is Ninth Circuit District Court case law to that end that's fairly recent. That's the United States v. Lonick case from 2016. One last important note here: while many employees can be subject to the privilege, only the control group has the power to waive. The control group has the authority to direct the operation of the in-house counsel. And because the client ultimately is the only one that can waive the privilege, only the control group can waive privilege. Okay, now let's go to the next one. A really tricky concept. Who is your client if you are in-house counsel? Imagine this situation. You are in-house counsel for Bear Company, and you have an employee of Bear Company, B. Grizzly, and in your role as general counsel, you have been assigned by the CEO to conduct an investigation into whether stock options have been backdated.
It's not good for the immediate value of our shares, but their revenue's way up, and they've introduced a bunch of
excuse
new
me?
products, so that could
Hey,
explain.
Robert,
So you're a lawyer, you've been assigned, you're the in-house counsel for Bear Company, you've been assigned to investigate whether stock options have been backdated, and you need to interview B. Grizzly, who is a corporate accountant, not a C-suite officer, but a lower level employee. Lauren, can you hit the next slide? So imagine that you, without thinking about this too much, you immediately go and conduct an interview with B. Grizzly. And during that interview, B. Grizzly tells you information that you immediately realize could expose Bearco to substantial liability, and it might even expose B. Grizzly to criminal penalties. Well, what happens now? What have you gotten yourself into? Well, can B. Grizzly assert a privilege to prevent you from disclosing information to the CEO? Let's say B. Grizzly says, hey, lawyer, you came and interviewed me. I reasonably expected that you were my lawyer. You're the in-house counsel. I see you at lunch every day. You're a lawyer. I know you're a lawyer. I told you a whole bunch of things that could get me into really big trouble. I thought you were my lawyer. And now you're telling me you're going to go disclose this to the CEO? No, I claim privilege, and I prohibit you. I tell you, you cannot disclose the information I told you.
Where are you going? To the gym? Okay.
Well, there is some authority that if B. Grizzly in fact told you to do that, and it was unclear to B. Grizzly whether you were or were not B. Grizzly's lawyer, then B. Grizzly can stop you from disclosing information that you learned in the course of the interview. The circuits are a little bit split on this question, but there's definitely authority, including in the Ninth Circuit, that strongly suggests that you could be prohibited from disclosing information.
Sorry, can you repeat that? Was that based on the fact that they didn't make it clear that they were in representation of Bearco?
Exactly. That is exactly right, Gina. If you walk into that interview without making it clear who you represent, it is very easy for a court to determine that the employee may reasonably believe that you represent the employee. And I'll talk in a minute about what kind of disclosures you need to provide. But this is a situation that happens really fairly commonly and often allows an employee or another individual to assert a privilege to prevent even in-house counsel from disclosing information. It also poses a serious ethical problem because you will have an obligation under RPC 1.6 not to disclose client confidences. And although there are some exceptions to that in RPC 1.13, they may not apply. The exceptions are a little bit narrow. And you may also have a problem because you may have a conflict of interest. You could find yourself in a circumstance in which you are representing both Bearco and the employee, and Bearco and the employee have adverse interests. So all of this, when you're out speaking with employees on behalf of the corporation, can cause a whole lot of ethical and other challenges. So what do you do about it? Well, on the next slide, we have a few suggestions. First, and most importantly, RPC 1.13F imposes an ethical obligation on those who represent corporations or other organizations to disclose affirmatively the identity of the client when you as a lawyer reasonably should know that the organization's interest could be adverse to the employee with whom you're speaking. So if you have some reason to believe that that employee and your client, the corporation, could be in an adverse situation, you have to identify the fact that your client is the corporation. Second, in order to ensure that the employee cannot assert a privilege to prevent you from disclosing the information you learned during the course of an interview, you must provide what is often called an upjohn warning. And I don't like that terminology, and I'll explain why in a second. But basically, an upjohn warning is where you inform an employee that you represent the organization, that you do not represent the employee, that the organization controls the attorney-client privilege, including whether to waive the privilege, and that the contents of the conversation that you are about to have with the employee are not necessarily confidential. And it's usually good practice to also inform the employee that they may obtain a personal attorney if they wish. It is really, really important that if you're in a circumstance in which it is critical to your organization to control the privilege, that you document that you have done this. In the Ninth Circuit, there is an existing case in which a district court made a credibility determination that outside counsel did not provide upjohn warnings before interviewing an employee. And based on that credibility determination, made a factual finding that no upjohn warning had been given, and that the employee could cause the could cause the lawyers not to disclose the contents of the interview. And that district court case was overturned on appeal, but it was overturned on a different basis. So it is really, really important that you write an email that records that you provided that warning to the employee. Okay, so the warning language can be a little bit scary, and often as an in-house counsel, when you're looking into you're investigating something just to see what happened, if you walk into the interview and immediately say, I don't represent you, anything you tell me isn't confidential and you should probably go get your own counsel, that's a pretty scary thing for many employees to hear. So it requires threading the needle between providing the employee with important information that will allow your organization, your primary client, to retain control of the attorney-client privilege, but doing so in a way that doesn't feel threatening or scary. And I don't have great advice on this, except I think it's just important not to conceive of this kind of disclosure as a warning. I would conceive of it as, you have some information you need to share, you're sharing it with all employees. It's part of your job duties and job job title that you've been hired to represent the organization. That's always been your job. Sometimes there can be a misconception that you represent the employees of the organization, and that's simply not true. And so kind of framing it in that fashion may be a little less scary than framing it as a warning and make it sound so threatening. Finally, an important reminder, a lot of times outside counsel.
Sorry, I'll interrupt you for just a sec because we just
Yeah.
got a question that was right on this follow-up.
Oh yeah, absolutely.
Which is on how often or how many occasions should the attorney give this upjohn information or warning? The first encounter, every time, periodically? Do you have a suggestion on that?
Yeah, that's a great question. It is likely that if you're investigating a single discrete matter, providing it once and then documenting that you provided it, for example, providing it orally and then writing a follow-up email in which you state that you provided this information to the employee, ought to be sufficient. You often see this circumstance, at least in bigger corporations, come up in the context of internal investigations, often when there's litigations going on around the internal investigation. So it might be an SEC investigation or a Foreign Corrupt Practices Act investigation, where there's also a criminal element. In those kinds of circumstances, when there are multiple litigations going on and you as corporate counsel might be speaking to employees wearing different hats. So for example, your investigatory hat, your counsel for the corporation hat in litigation A and in litigation B. In those sorts of circumstances, it's really important to be clear in which context you're speaking with an employee. And this was the fact of multiple litigations and confusion about who counsel, under what circumstances counsel was speaking with an employee is something that's come up in a number of cases and has led to employees feeling confused about whether the lawyer they're speaking with represents them in that particular context. And finally, I just want to say it's important to make sure to just remind your outside counsel to provide upjohn warnings. Outside counsel, and I say this as a person who's outside counsel, we as outside counsel always try our best to fully understand what our clients' goals are. But it is very easy as outside counsel that doesn't work directly for a corporation day in and day out to forget or to fail to fully consider how important the privilege is to the corporation itself. And so if it is important to you as corporate counsel to ensure that your corporation is retaining control over the privilege, I would speak to your outside counsel if they're conducting an investigation and remind them to provide clear and unambiguous upjohn warnings before the start of each interview, and to document those upjohn warnings to ensure that they can prove it to a court if it becomes an issue. Okay. There's a lot more on this topic.
I know. Harry, I was gonna say, I think we've already passed our halfway point, and I think we promised everyone some raffles. So we're supposed to
let's do some raffles.
Pause, and Carrie is gonna do a raffle, and maybe two, because we skipped the one at the beginning before we get to this exciting slide. Oh, Carrie, we can't hear you. You're still on mute.
Sorry about that rookie mistake. I've got a wheel of fortune here. I'm going to click on it, and we are raffling off a fabulous Portland Thorns scarf from 2022. And the winner is Guy Thompson. Guy Thompson is the winner. Let's
Congrats.
do, yay, Guy. Let's do, I'm gonna write that down. And then let's do one more for a bottle of Cristom Viognier Estate 2018. If you can see that, it's all fuzzy. All right, let's do this. And the winner is Alfred Bowen the third. Alfred Bowen, congratulations. We've got one more that we'll do at the end.
Great, thanks, Carrie. So as I was saying, the Upjohn issues are really complicated. If you have questions afterwards, please shoot them to us. But that's the kind of thing that if it's a big, serious matter, you definitely want to consult your research guides or outside counsel if necessary. So let's really quickly cover a few quick other privilege issues. One of the ones we hear most often in a litigation context is, hey, opposing counsel is calling our employees. Are they allowed to do that? And the answer is probably yes. Under Oregon Rule of Professional Conduct 4.2, a lawyer cannot have communication with a represented party. But that rule, as it's been interpreted by the Oregon State Bar, is not necessarily coextensive with Upjohn or the OHSU case. And that's because outside counsel might not know who fits as an employee for the purposes of the privilege, because they're just not in it. So what the Oregon State Bar has said is that opposing counsel cannot contact control group like people, officers, member managers of LLCs, board of directors, that sort of thing. And they cannot contact lower level employees whose conduct is at issue in the litigation. So if it's a tort claim about a car accident, and the driver was driving for a freight company, they can't contact the CEO of the freight company, and they can't contact the driver of the vehicle that was involved in the accident. But they can contact anyone else, including former employees and former officers. The only restriction on this is that opposing counsel may not ask into or permit a current or former employee to disclose a privileged conversation. Let's do the next slide, Lauren. We've got a whole bunch of slides on this, but I want to cover it really quick so we can get to work product. There are a few things to keep in mind that are not privileged and are almost never privileged. There are a few exceptions to everything. First of all, the fact that a particular corporation has either in-house or outside counsel is not itself privileged, nor is the name of the counsel, the fact of the communication, the date of the communication, who was participated in the communication, or how long the communication was, or how long a meeting lasted. And next slide, Lauren, facts are not privileged. We'll send this PowerPoint out right after the CLE. I really encourage you to look at the quote here from the City of Philadelphia case. There's an important distinction between a communication that includes facts that have been gathered at the request of a lawyer or that are being disclosed to a client through a lawyer, and a fact that is learned in some other fashion. The communication itself may not be disclosed, but a fact is never privileged and can be disclosed in interrogatories or depositions or in some other discovery channel. And this quote really summarizes it well. Let's do the next slide. There's also a whole category of communications in case law and things called dual purpose communications. These are communications in which a counsel and a client talk about more than one thing. One part is a legal communication, the other part is a non-legal communication. And in the Ninth Circuit, the determination of whether that communication is privileged hinges on whether or not the communication's primary purpose is to seek, obtain, or use legal advice. Next slide. There's a new recent case on this in the Ninth Circuit. That's the site there. In Ray Grand Jury decided just a few months ago. Summarizes this well. And the quick tips on this are just to remember to always phrase it. If you want to make sure that a dual purpose communication is privileged, that you're being very clear that the primary purpose is for the rendition of legal advice. One last important thing. And this comes up fairly often, and it's come up in some of the biggest corporations that I've been involved in litigation with. And that's the practice of copying counsel on emails in order to make it privileged. That does not work. I love this quote from a Northern District of Illinois case. The mere presence of a lawyer's name at the bottom of a document is not the bell that causes the dog named privilege to salivate. You cannot just CC counsel and make it privileged. And you also cannot just put attorney-client privilege in the subject line of an email. That is not what matters. But I will say, as a practical matter, putting attorney-client privilege in the subject line of an email that you believe is privileged and that you want to make sure your litigators understand is privileged, and your review team that's producing documents will take a hard look at. It's really nice to see that attorney-client privilege in the subject line. So that's privilege. I'm going to turn it over to Lauren now and talk about work plans.
Okay, thanks, Harry. And so we're going to talk about one of my favorite flavors here, which is work product, which I often see attorneys, what I would say, mush together privilege and work product. And if you can have one takeaway from today, my hope is that you will not mush attorney-client privilege and work product together and see them as two separate, distinct things, because they are. And one of the reasons work product is different is it's not a privilege, it's a protection. It's a qualified protection from discovery. And it's sometimes called the zone of privacy to protect a lawyer's preparation of her case and legal strategy. And it's focused on the attorney's preparation of the case rather than just on the client's confidential communication. It was established by the US Supreme Court in the Hickman v. Taylor case in 1947. And it's partially codified in the federal rules of civil procedure and in most state rules of civil procedure, for example, Oregon Rule of Civil Procedure 36B3. So courts generally distill work product down into 3 requirements to qualify a thing to be protected. Documents, there has to be a document or tangible thing, or an intangible thing, like the attorney's opinions and strategy. The most important prong, in my opinion, is it has to be prepared in anticipation of litigation. And we'll talk a little bit more about what qualifies as that. And then it has to be prepared by a party or for the party. And what is one of the reasons work product is a bit broader than privilege is that it can include non-lawyers. And some examples of that would be if you as the corporate attorney ask a group of employees to put together a spreadsheet to calculate potential damages of lost contracts due to a supplier contract being breached, that could be covered by work product. Also, if an outside consultant is hired to do an investigation, their draft reports under many circumstances can be work product, or work with media consultants. Similar to the vein Harry talked about in attorney-client privilege. If you hire a public relations firm to help with media strategy in response to litigation, in many circumstances, courts will find that protected by work product. So it doesn't always have to be at a lawyer's direction, but that is the safer route to show that whatever work is being done by a non-lawyer was done in anticipation of litigation. It's going to be more likely protected if that's something that you as the in-house lawyer have directed others to prepare. So what is covered? It's broader than attorney-client privilege. It covers more than just communications. And the case law generally breaks down into 2 categories: opinion work product and ordinary work product. Opinion work product is the material prepared by an attorney that contains mental impressions, conclusions, opinions, legal theories. Essentially, it's the attorney's interpretation of legal theories and application of the facts to those theories. And it can encompass, again, not only the attorney's mental impressions, but mental processes of persons assisting the attorney, paralegals, consultants, experts, other law staff working at the law office, and included a couple examples on the slide deck. And one I want to point out in particular, that second to last bullet point, is one that's often overlooked, and that's an attorney's selection of key documents. So most courts do recognize that an attorney compiling particular documents, say for a witness to review, reflects that attorney's mental processes. So even if the underlying documents might not be privileged, which particular set an attorney put together and presented to a witness to review may be considered work product. And in the same theme Harry talked about earlier, though underlying facts are not protected. So even if you have a document that's being withheld under work product protection, you may still need to just redact portions of that and then produce it if there's underlying facts that are not protected by work product. Okay, two of the significant limits on work product are that prong I talked about earlier, that it has to be prepared in anticipation of litigation. So this is specific. Courts will look at specific scope and time period for when the corporate entity anticipated litigation. And the burden is on the party claiming work product to demonstrate that a threat of litigation was imminent, and it attaches once the party has a basis for believing that litigation is likely. And just a general ever-present fear of litigation in the future won't meet the requirement. Also, the fact that a contract has provisions in it like a dispute resolution provision or a choice of law provision that courts typically have said is not sufficient to say that the parties anticipated future litigation about the contract or about the settlement agreement. And similar to what Harry talked about with dual purpose communications in the attorney-client privilege context, that does also come up in work product. A document prepared in the regular course of business that doesn't mention the litigation at all would ordinarily not be protected by work product. You would have to show that the document was generated, was motivated by the litigation, and the test that the Ninth Circuit applies is also laid out in the recent Ninth Circuit case that Harry mentioned, and we'll circulate that with the materials. The In Re grand jury case talks about how it's a because of test, which is broader than the primary purpose test for attorney-client privilege, but was the document created because of the litigation? Okay, the other limit is that it's not an absolute privilege, and the rules of federal civil procedure lay out the avenue by which an opposing party can, in some circumstances, access work product through discovery. So I skipped over ordinary work product. We talked about opinion work product of the attorney. Ordinary work product is basically everything else. It's defined in the negative. So attorney work product that doesn't contain opinions. So the classic example of that would be an attorney takes notes in a witness interview and just writes down verbatim what the witness says and doesn't editorialize or write any strategy thoughts in those notes. That type of ordinary work product can be discoverable in some circumstances. The party requesting it would have to show a substantial need for the materials, and that it couldn't get a substitute form of discovery without undue hardship. So a classic example of that would be the same witness interview. The witness passes away and there's no other way for the opposing party to get access to that information. The court might order production in that circumstance. But for opinion work product, courts afford greater protection and the standard is a little bit higher. To be discoverable, the opposing party would have to show extraordinary need. Okay, so the distinction between attorney-client privilege and work product, I think, is particularly interesting when you get into the issue of waiver. And this is where I've had to really think deeply, to brief and argue these differences to courts when we've gotten into situations around waiver. So this is the high level takeaway that I hope you will take from today, is that if you, and we'll talk a little bit more about waiver in the next couple slides before we wrap up and go to questions. But what I hope you take away is that for attorney-client privilege, the waiver occurs if the client voluntarily discloses the information. And the easiest way to do that is to share it with a third party. And as Harry talked about in the control group for attorney-client privilege, that is the same group of people for a corporate entity that would have the ability to waive the privilege. Essentially, only the control group can waive it. Courts have said that employees or former employees ordinarily can't waive the privilege unless they have implied or express authority to do so. And anytime there's a waiver of attorney-client privilege, there is a risk of subject matter waiver, meaning that once the privilege is waived, it's waived as to all related communications on the same subject. Though the parties can take advantage of Federal Rule of Evidence 502 to limit the scope of waiver. I'll talk a little bit more about that in just a moment. But for work product, waiver is more forgiving, in part because the attorney, not just the client, can assert the work product. So in some situations, if the client has waived the work product, say by disclosing it to a third party, the attorney can still assert work product over those materials. And the test is a little bit different. So for work product, the court looks at, for waiver, whether that disclosure to a third party substantially increased the opportunity for the adverse party to obtain the information. So the court will look at factual differences between the client posting the work product material on the internet versus sharing it with one person. Those kind of factual differences can matter in this work product waiver analysis. And the scope of it is generally much narrower. It's generally limited just to the documents or materials that were disclosed, not to the entire subject matter. Okay, so I want to dive into waiver just a little bit more and talk a little bit about how to prevent it, and then also what to do when it happens. So a situation where an ounce of prevention is worth a pound of cure is definitely in this situation around protecting privilege. And under the rules of professional conduct 1.6c, you do have a duty of reasonable care to avoid the disclosure of any confidential client information. And that includes taking steps to prevent inadvertent disclosure. And some tips here that we have include reminding your clients early and often about privilege. I do not hesitate to explicitly state on important memos or emails at the outset of the email, this is privilege, don't forward it, explaining that to people orally also, or asking people, don't forward this to anyone. If someone else needs to see it, please check with me. It's always better if then the attorney can send the material to this additional person on the team rather than non-attorneys forwarding it between themselves. And put a clawback provision in your stipulated protective order. If you're in litigation and you have a protective order that's going to govern producing documents to the opposing party, that will serve you down the line if you're in this situation. I have definitely learned this the hard way. I've seen clients, sophisticated business people, forward emails from their attorney containing legal strategy, forward drafts of briefs to a friend or to a trusted business confidant who is also a lawyer. And the client just assumed that because this other person was a lawyer, it would be okay, that it was covered by privilege, that it would never get disclosed. And this can have really detrimental consequences if this type of waiver by disclosure to third parties occurs, particularly when that third party then gets a subpoena in litigation and the information gets disclosed that way, or you're doing an email collection and producing emails, and then in doing that, you discover that your clients have forwarded information to third parties. You have a much steeper hill to climb. I found an added layer of protection that has been helpful is sometimes using these secure file links if you're sending a large volume of information, particularly that's sensitive or privileged. If you use a secure file transfer and then find out it was shared with someone else, you can always shut down that link, or you can go on the back end and then see who accessed it. Okay. Just a few more pieces to cover, and then we'll wrap up in time for hopefully another question or two in our last raffle. So what to do if waiver has occurred, and it's your office or your client that has disclosed. You're going to want to immediately look up and look at Federal Rule of Evidence 502B, and that limits subject matter waiver to voluntary disclosures, but it eliminates the broad subject matter waiver for inadvertent disclosures. So you'll want to figure out, was this a voluntary disclosure? Was it inadvertent? What are the circumstances? Immediately follow up with the person who disclosed the information to find out some context, explore whether potentially you have an argument it was an inadvertent disclosure. Check to see if attachments or any secure links were downloaded from, and have a conversation with your client about the disclosure and about best practices going forward, and use it as a learning opportunity. And then I also, if I determine there's been an inadvertent disclosure, immediately follow up with the third party and with opposing counsel in writing, and ideally at the same time, identify all of the affected documents, cite the clawback provision in your stipulated protective order if you have one, produce replacement copies with redactions, give the opposing counsel a deadline by which they're going to confirm the documents have been deleted, and put it on your privilege log. All of these things are important because the court, if you get into a dispute over whether or not it was an inadvertent disclosure and whether or not there's been a subject matter waiver, the court's going to look at factors about what was done to rectify the error if that occurred. Okay. This last piece. So what about if you are on the other side of this situation, and you or your client discovers a document that the opposing party has disclosed? And so a couple considerations that should pop into your mind. So one is, I want to point out here your obligations under the Oregon ethics rules. And there's an ethics opinion. There's actually two on this issue, and we'll include that in the materials. And this ethics opinion talks about how Oregon Rule of Professional Conduct 4.4 requires that if you discover this, you have to notify the sender. So you have to notify the other party and allow them to take some adequate protective measures. But the rule does not require you to return the originals, return that information. That is something, then your second consideration is going to be your professional judgment, and you need to have a conversation with your client, consult with them about the risks of returning the documents versus not doing so. And if you're in federal court, you need to pay close attention to the federal rule here, 26B5B, which does go further than the Oregon ethics rules, and it does require you to return, sequester, destroy the documents, and take reasonable steps to retrieve other copies if you've given them to experts or circulated them further. And you can then present the information under seal to the court to dispute the claim of work product or privilege. And then your fourth consideration should be too, if you have a clawback provision in a stipulated protective order, take a look at whatever procedure you've agreed upon with the other party. Okay, I think we came in just at the clock. Yes, so why don't we, Carrie, could you do our other raffle? And then I'm happy to stay on for a few minutes if we have a few more questions.
Absolutely. So our last raffle prize is a $50 gift certificate at Bistro, which is the new restaurant in our building, the Broadway Tower building, owned by Marshawn Lynch. And the winner is, I'm happy to report, is Abra Cooper. Yay, Abra. I'll be emailing you all the information.
And we will also send out a copy of the slides and the Ninth Circuit case, was it in re subpoena, and the ethics opinions we talked about. So you'll have those materials. And then Carrie, I think we're also submitting names and information to the bar for CLE credit.
Yes.
Okay. Great. Okay, I think we jam-packed a lot into 1 hour. If you didn't get a sense of this, Carrie and I both do actually really enjoy litigating privilege issues, talking about them, thinking about them. So if there's a follow-up burning question you had, you didn't get a chance to ask, please shoot us an email.
Thanks, everybody.
Okay, thanks everyone.
Thank you.
Thank you.
Bye. Have a nice evening.